Well, good afternoon, everyone. Cynthia Tomane here with Interactive Brokers, and thanks for joining us this afternoon. But for right now, what I am going to do is I'd like to introduce my colleague, Will Katz, who's going to give a brief intro, and then we'll get into today's session. So, Willie, I've passed you the ball. It's now yours. Please take it away.
Okay. Can you hear me, Cynthia?
Oh, certainly.
Okay.
Loud and clear.
Excellent, excellent. Good afternoon, everybody. My name is Will Katz, and I work with institutional clients over here at Interactive Brokers. If you have any questions or need any information on the Interactive Brokers offering or our capital introduction program, feel free to reach out to me or to your rep who recommended this webinar. Okay, the Jobs Act. First of all, the Jobs Act. This past September 23rd marked the one-year anniversary of the enactment of the Jumpstart Our Business Act, or what is called the Jobs Act. The Jobs Act was designed to spark U.S. economic growth, but relating to private fund managers, the most significant aspect of the rulemaking is the addition of the lifting of the ban on general solicitation and advertising in private offerings. The Jobs Act provides an opportunity for private fund managers to communicate to potential accredited investors. As a result, hedge funds are now allowed to employ tactics such as engaging the media, building accessible websites, advertising, and even social media. The competitive pressures outside of performance numbers are now pushing hedge fund executives towards greater acceptance of new and developing communication channels. There's some interesting metrics that are now starting to emerge as managers start to take action and participate in general solicitation. 66% of 2014's largest 292 hedge funds are now on LinkedIn, and 10% are on Twitter with an average of 15,000 followers. That's a lot of movement with hedge funds and engaging in general solicitation. Among the largest 285 global hedge funds in 2013, 14% have now launched websites as of last September. So the ability to advertise your fund, it's definitely arrived. The opportunities to be more transparent, demonstrate financial insight, and engage in thought leadership continue to emerge. What's yet lacking is the clear desire to fully employ these platforms strategically and to understand the legal and compliance landscape the SEC has outlined. So for the purposes of today's webinar, we are fortunate enough to have teamed up with Doug McLean from ARMA Compliance to address some of these issues. A little bit of background about Doug McLean. Doug McLean is the managing member of ARMA Compliance. Mr. McLean has been an attorney in Boston and New York City for over 15 years. He is admitted in the state and federal courts in the Commonwealth of Massachusetts and also the state of New York. Mr. McLean graduated cum laude from Harvard College in 1994. He's also he graduated from Cornell University in 2000 with a JD from Cornell Law and an MBA from the Johnson Graduate School of Management. And lastly, a little plug for Doug's ARMA Karma Foundation. This is a foundation he started and that rewards and recognizes Massachusetts high school students who are givers. Doug, good afternoon and welcome. Hello?
Willie and Cynthia, thanks so much for the kind introduction. I really appreciate the kind words about my foundation and whatnot, and I really appreciate everyone's time today. I know how valuable everybody's time is, and I really appreciate your time this afternoon. First and foremost, I just want everyone to know that this presentation is designed for you, so to the extent to which you have questions going forward while I'm discussing any of these materials, please feel free to, I have access to the interface on the WebEx event, so please feel free to chime in with questions. This really is designed for you. So at any point you feel as if there is anything on on your mind about that, about anything that I'm discussing, I'm happy to address it. Certainly, if the questions become quite significant, I might leave them for the end. And certainly, if something is a question that I'm going to address later, please feel free to not be ignored. But if you have anything that you're confused about, please feel free to reach out. We'll really provide a little bit of background about the Jobs Act. I have a number of slides I'm going to walk through here and to provide some more information about specifically how this applies to emerging hedge fund managers and hedge fund managers in general. Just in general, I think that the Jobs Act actually encompasses a number of different sections. There's a piece of the Jobs Act that applies to non-accredited investors. There's a piece that applies more to operating companies. And certainly, while those are valid provisions, those really aren't going to be discussed on today's webinar. This focuses really on the Jobs Act and how it really applies, the sections that apply specifically to hedge fund managers and their ability to raise capital. So for folks who are interested in those other provisions, unfortunately, those will not be addressed today. And here's a little bit of background about Arent compliance. I'm based in Boston, Massachusetts, and unfortunately, I'm a Red Sox fan and was a little depressed about our past season, but certainly you can't win every year. Anyway, here's an overview of today's presentation. First part's going to be an overview of the Jobs Act. Part two sort of reflects proposed rules that are out there and have not yet passed. Other compliance issues that are involved with the passage of the Jobs Act. And then just at the end, a cost-benefit analysis for emerging managers. Going to give you sort of my personal insight of some of these issues related to my role as both an attorney who represents a number of hedge fund, private equity funds, and emerging managers who have taken advantage of the Jobs Act, as well as a compliance attorney who's been involved in, at this point, 20 SEC exams in the last 2 years. So here's kind of the overview per se, and I think if you're going to come away with anything today, this slide that I've shown you is a quick overview of federal securities regulation. I'm going to really try to boil this down to its essence just so everybody understands exactly what I'm talking about, just sort of frame the conversation. So, and mind you, we're just talking about, federal in the United States. We're talking about securities regulation. There's a lot more complexity here than what I'm presenting with these specific issues on the state side. There are state securities regulations. There are other laws that apply. But just in general, I'm trying to give you a basic overview of exactly what we're talking about so you can understand, give you a framework of today's discussion. So if you were to look at this and one of my things I learned earlier today, that they have the pointer in the seminar, which is really exciting. So if I overuse the pointer, feel free to ask a question about my overuse of the pointer. So anyway, if you look at this triangle here, this is a private fund. This is for argument's sake, we'll call it a Delaware limited partnership. It's formed. It's basically a pool of money. Its assets are cash, securities, and other investments that a private fund would make. And let's assume just for today's discussion that it is a hedge fund. So it's a privately offered fund that's currently relying on the issuing security. So just to explain how this whole process works. So you have an investor, hedge fund investor. This arrow in basically they contribute cash comes in here. Okay, so they sign a subscription agreement. They contribute money to a fund. In return for that money, this interest out, which is an interest in that fund, this is a security coming out here. So generally, what's involved here is the Securities Act of 1933. So generally, with all these rules you'll see up here, is you either comply with the rule or you find an exemption. That's the general thought here. So I'm probably more of an entrepreneur than a compliance attorney, so I'm a huge fan of trying to find exemptions. So the less compliance you can certainly deal with, the better off you are and the easier your business will run. So here, this interest cash coming in, security going out, that's governed by the Securities Act of 1933. The Jobs Act basically amended that whole act. That's really where this is what we're talking about today. So that really involves with the amendment and where that all occurs. The fact that the 33 Act, and which is federal, it's in the sense of the federal securities laws. It was passed by Congress. Congress promulgated to the SEC to pass particular rules that will allow those provisions to be reflected on the Securities Act. So that's basically what we're talking about today. Is that whole piece right there involves the 33 Act, and this is what's got amended. So just in terms of what we're talking about. If you were to take this page and sort of go down the middle of the page here, this side of the equation, so this is your fund, okay? This side of the equation is actually called your own company. Think of this as your general partner, your managing member. This is sort of the people that run the fund. So there's this distinct between the fund, the money per se on the left side, and the people who are actually managing the fund on the right side. So I think that's one of the things that I see for people who get confused about compliance is they collapse compliance. They assume that there's compliance on your fund. Always think about you have compliance on your fund, you have compliance on your manager. Two separate issues, and I think the more you can keep those separate, the easier it will be to understand exactly what your compliance needs are. So let's just think here. So now we've got this fund is entering into an investment advisory agreement with a hedge fund manager. Say this is a Delaware limited partnership. It might have a managing member or a general partner. The GP on behalf of the fund enters into an investment advisory agreement with perhaps another Delaware LLC that's a hedge fund manager. So one element of this equation you have to think about, and because I'm going to talk about advertising, I just want to make sure that people understand that a hedge fund manager is also subject to the Investment Advisors Act. So, and there's advertising rules that apply to both the manager as well, too. The advertising rules we're going to talk about today apply to the fund here. They're not here. So on this side of the equation, on the people side, there's basically three statuses you can have. Actually, there's four. You could either be registered with the SEC, registered as an investment advisor with a particular state. You can be what's known as an exempt reporting advisor, or you can be actually nothing. So a lot of that depends on a number of factors. It depends on your assets under management. It depends on the types of clients you have, and it depends on the particular state in which you conduct your principal place of business, where the hedge fund manager is located. So unfortunately, today's topic is not going to involve anything on this side of the equation in terms of whether your particular hedge fund manager has to register on the Investment Advisors Act. Under the Advisors Act, whether you're registered with the SEC or a particular state, there are advertising rules. So even if you have a private fund that's taking advantage of the Jobs Act on this side, you still, if you're a registered investment advisor, still have advertising rules on this side here. So I just want to make sure people understand that we're just talking about the triangle today. We're talking about the fund advertising rules. Whether you have advertising issues on this side is depending on your own regulation status. So in terms of the down here on the so again, this is the fund, this is the management company or the investment manager of the fund. So just to give you, and I'm not going to get into this too much, but I think these are important issues because I think it's probably something everybody's talked to you about, but I'm just really trying to boil this down to its essence here so people can have the ability to understand probably some of the stuff that's in their legal documents. So this fund here, as I said, takes cash in, issues securities out. This is similar to any operating company. So the difference between a fund and perhaps a private company like a real estate property that wanted to do a private placement. So it wanted to have investors who would wanted to invest in securities in that real estate offering. So call it the MGM hotel in Vegas wanted to do a real estate securities offering and issue securities in that particular hotel in the MGM hotel. So the distinction between a fund per se and the MGM hotel is this fund actually, so how it works is it takes the cash from investors and invests in securities. Because it not only issues securities, the actual investment down here of in public or private securities, if it's public, obviously it's a hedge fund. If it's private securities, it's a venture capital or a private equity fund. But because it issues securities and invests in securities, this investment in securities makes it subject to the 40 Act, the Investment Company Act of 1940. So again, as we talked about exemptions, you either register under a particular exemption or you get an exemption. So for this particular, for the 40 Act, the two big exemptions you probably heard of are 3C1 and 3C7. Those are sections under the 40 Act that allow a private fund to be exempt exempt from the 40 Act. So your typical mutual funds is registered under the 33 Act. It's also registered under the 40 Act because a mutual fund would issue a security here to an investor, but it would also invest in securities. Unlike perhaps a public company like Facebook, Facebook issues a security pursuant to the 33 Act, so they're registered under the 33 Act, but they're not a 40 Act. They're not registered under the 40 Act because they actually, Facebook's a marketing company, and they're involved in online, they have an online platform, not like a hedge fund that issues security and then invests in securities. So most operating companies don't have to deal with the 40 Act, and there are exceptions to that, but just in general. So, and then last but not least, I just want to throw this out there. There's another federal securities law they call the Securities Exchange Act of 1934 that involves like soft dollars, broker-dealers, insider trading, particular rules under that those are out there as well too. But the key to today is I just want to focus what we're talking about today is we're talking about this fund basically subject to the Securities Act of 1933 and its ability to now be, with the Jobs Act, its ability to market and advertise this particular fund that it couldn't do before. So that's really what we're talking about here. That's the triangle of compliance and legal issues we're talking about today. Okay, so first, just as Willie mentioned, the Jobs Act on the general side was passed by Congress in 2012, really was designed to allow companies to have better access to capital and capital formation. That was the really primarily goal of it. So that was passed. So Congress said in April of 12, we really want to have companies have the ability to have easier ways to raise capital. So this Jobs Act amended the Securities Act of 33. We just talked about that. That's that first triangle of issuance of securities where cash comes in and securities go out. So basically, Congress said that, and Congress told the SEC, okay, you've got to come up with rules and regulations to codify this Jobs Act and really make this work for emerging managers such as hedge funds. So in general, what the general gist of the Jobs Act says that under the Securities Act of 1933, the SEC a number of years ago passed Rule 506 of Regulation D and said that basically that's a safe harbor. We talked about with any compliance, you either get an exemption, you either register or you find an exemption. So in order to not have to register as a public company under the Securities Act, the SEC passed Rule 506 and Regulation D, which basically said that to the extent to which you want to do a private placement, meaning you're only doing a private issuance to investors, you can't use general solicitation and general advertising. That was the general pre-Jobs Act. That was the rule. Like if you want to have a private placement, you don't want to register under the 33 Act to become a public company, you have to not engage in general solicitation and general advertising. That was the pre-Jobs Act rule. So Jobs Act comes along in April of 12 and tasked Congress to come up with it. So as mentioned, in September of 13, basically the SEC came out with particular rules, which we're going to talk about today about the Jobs Act. So just to, and this now allows private funds or hedge funds to engage in public marketing. Prior to the Jobs Act, Reg D said that to the extent in which you wanted to do any general advertising solicitation of your private fund or send out any article, advertisement, seminar, or anything to promote an offering, that was illegal under prior to the Jobs Act. Now, with the passage of the Jobs Act and the rules that the SEC passed in September of 2013, that's now allowed. The challenge is there's now additional compliance, and now we're going to talk about what did the Jobs Act actually say, what's the additional compliance here, and what were some of the other proposed rules that the SEC passed or proposed in September of 2013 that emerging managers should be considered. So, as mentioned, July of 2013, the SEC passed final rules regarding the Jobs Act and proposed additional rules. So what this basically allows is any of those restrictions under Reg D that said you can't engage in a public offering, you can't do any general advertising, those actually are now allowed. So, for example, just to tell you exactly what you can do now. So to the extent in which you have fund documents for your hedge fund that, it's a private placement memorandum, it's a limited partnership agreement, it's a subscription agreement, you could now put those on your website and basically allow people to see your fund documents right on your website. That was before the Jobs Act and the SEC rules in this last year were passed. That was not allowed. Now that is currently allowed. But with that, there's additional compliance. So what's the additional compliance? So what the SEC said was, if you do want to take advantage of the Jobs Act and engage in general solicitation and general advertising, you have to make sure that all of your investors are accredited investors. So currently under and to distinguish between, sort of going to distinguish between the current or the pre-Jobs Act rule is now referred to as Rule 506B, B as in boy, and the new Jobs Act rule are now referred to 506C. So that's the 506C is now the rule that the SEC passed that allows private fund managers to engage in general solicitations. So 506B is currently still in place, no changes to that. So folks who don't want to engage in the additional compliance and engage in general solicitation and advertising can still rely on 506B, but now they have the option to rely on 506C. I'm going to talk about that a little bit more later, but I just want to throw those two terms out there now so people have that. So if you do a 506C offering, meaning you're taking advantage of the Jobs Act, the only investors who can come into your fund are accredited investors. Currently, under the Regulation D and 506B offers, as in boy, you can have up to 35 non-accredited investors come into your offering. So certainly those who are looking to take investors who aren't accredited investors, certainly you should continue to rely on 506B. And also, in addition to having everyone be an accredited investor, the SEC also has that you have to have a reasonable basis to believe, and you actually have to verify that all the investors in your fund are accredited investors. So simply getting a representation warranty in your subscription agreement that a particular investor is an accredited investor certainly works under 506B as in boy, but no longer works under 506C. You actually have to have more compliance involved to actually use 506C. So let's talk about that a little bit more. So, and as mentioned, so this talks about the distinction between 506B, 506C. The current rules still are in place. So to the extent to which folks are interested in continuing to rely just on 506B, you must refrain from a general solicitation and advertising. For example, putting your fund docs on the internet would not be allowed. It certainly would not be in compliance with Rule 506B. But under current or under 506B, you don't have to take reasonable steps to verify the status of accredited investors. So certainly, if an investor represented a warrant in a subscription agreement that is accredited investor, and you had no reason to believe otherwise, you didn't see that he filed for bankruptcy earlier that day when you got a subscription agreement, you certainly can accept him. No need to verify anything. That's not the same in 506B. You do actually have to take reasonable steps to verify the status of accredited investors. And still under 506B, that hasn't changed in any way. You do have to make sure you have a pre-existing substantive relationship with your investors. And certainly, as mentioned before, the fund interest can be sold to non-accredited investors, which is not true under 506C. So a few things that the release that came out in July of 13 made clear, that to the extent to which you decide, perhaps in November of 2014, decide, well, I really am struggling to raise money. I'd really like to try some alternative methods to gain access to investors. I'd like to try the Jobs Act. To the extent to which you decide in November you're going to rely on 506C, any solicitation that you make in November of 2014 or even thereafter doesn't affect your prior investors that you solicited under 506B. So that's the good news. To the extent to which you had other investors who came in before, certainly using the Jobs Act later doesn't in any way affect your compliance that you had to deal with for your 506B investors. So to the extent to which this whole test of taking reasonable steps to verify that purchasers of securities are accredited investors, that's where the SEC had quite a bit of analysis in its release about what do you actually have to do to take reasonable steps to verify that a particular investor is an accredited investor. And there's a number of factors involved that I'm going to talk about now that certainly can be considered in considering whether a particular investor is an accredited investor. Factors that to be considered, these are all from the SEC release that came out in July of 13. So certainly the nature of the purchaser, if you look at the definition of accredited investor in Rule 501, there's a number of different categories. There's accredited investors, there's banks, there's all different categories of institution and non-institutional investors who can be an accredited investor. Certainly, if an investor is a bank, that requires less diligence than someone who's a natural person who's investing. So certainly that's one consideration that to keep in mind. Secondly, the amount of type of information that the fund has about the purchaser. Again, if someone makes representation warranty in a subscription agreement that they're a bank, it's very easy to verify the status of a bank. Again, if someone is a natural person, obviously more steps must be taken to have a reasonable steps to verify whether someone's an accredited investor. And also, the nature of the fund offering comes into play, the manner in which the purchasers were solicited to participate in the terms of the offering, such as the minimum investment amount. Certainly, if someone was investing in a hedge fund that had a $5 million minimum and such investor was making a $5 million minimum investment, certainly that investor would certainly satisfy the accredited investor test. So certainly those types of the terms of the offering amount, the manner in which the purchaser was solicited obviously factor into these analysis whether there was reasonable steps to verify that a particular investor was an accredited investor. And one thing I would mention is you certainly want to make sure that you maintain reasonable and adequate records to maintain that you verify the status of accredited investors. One note that I counsel clients, and I think this is the challenge I think for the Jobs Act is folks are looking to really gain access to accredited investors, but the challenge is that they're concerned about asking too much information from investors and making them provide, for example, tax returns, other information that they can verify. Certainly, one of the things that I've counseled with clients and provided for them is a letter from, and we'll talk about this in a little bit, a letter from a licensed third party that they can provide on behalf of the investor. So at that point, it makes the process a little more seamless. The investor wishing to invest in the fund does not need to provide so much information that perhaps confidential information that they don't want the end hedge fund manager to have access to, but certainly they're comfortable with a licensed CPA or a licensed attorney providing a representation and warranty on their behalf that they meet the test of an accredited investor. So that's one thing I've counseled clients to consider, so it makes the ability to use a third party a little more seamless. So I just described third-party information can be used to document and provide evidence that a particular investor is an accredited investor. Certainly, this could be something provided by a third party, such as something that you provide to the IRS. So to the extent of which the purchaser is a natural person, you can provide copies of pay stubs for the 2 most previous years and the current year. So as I'm not sure if folks are aware, but there's 2 ways that a natural person can satisfy the accredited investor test. It is that they have an annual income of a loan of $200,000 for the past 2 years, or $300,000 with a spouse, and have a reasonable expectation of meeting that amount in the next year. So certainly one way you could do that is have the potential investor provide pay stubs that show the amount of their income for the past 2 years and the current year. Other things about specific information about average compensation at purchaser's workplace. So to the extent of which you have information about your investor that's publicly available, that would satisfy that test as well too. And then there are, as I mentioned, third parties. We'll talk about that in a little bit. There's actually some services on the web too that will provide that for accredited investors as well too. I haven't had any experience with those. I think the easiest way is for everybody's interested in having the investor as comfortable as possible. So I think existing service providers that they have a relationship with, I think, are the best ones to provide this, third-party accreditation. I think, services that pop on the web, if you have to provide, pay stub or tax information to a third party on the web, they probably are concerned about confidentiality of that information. Certainly, it's probably just easier for them to deliver it right to the hedge fund manager. So my suggestion on that is to get a third party who's very comfortable and familiar to the investor. They can certainly provide a letter to certify that they are an accredited investor. So just to be clear, and this is a distinction between a 506B offering and a 506C offering, is that reasonable stuff to verify an accredited investor does not include checking a box on a subscription agreement. So unfortunately, the fact that an investor in a 506C offering sign a subscription agreement indicating that they're an accredited investor, that certainly works from a 506B perspective, unless, of course, you have reasonable information to believe otherwise, but that will not satisfy 506C, so just keep that in mind, too. So the SEC basically provides 4 specific non-exclusive methods to verify accredited investor status, and I'm going to talk a little bit about that. First, you can, again, I think to verify an accredited investor, I mentioned before that you can use the annual income test, and we talked about $200,000 for a natural person, $300,000 with a spouse, and a reasonable expectation of hitting that the next year. So There's also a net worth test as well, too. The net worth test is basically $1 million, and that includes, it's liquid net worth. It does not include your home. It doesn't include your primary residence. It does include, some rental property, but it does not include your primary residence. And you also have to, deduct out any liabilities against your residence. So it's a complicated test, but in general, it's $1 million of net worth. So to the extent of which you're trying to use the net worth test to have for someone to satisfy the accredited investor test, bank statements, brokerage statements, and other statements can certainly suffice in that situation. So to the extent of which you're ever asked to provide a reasonable basis for your belief that someone is an accredited investor and that you verified that, certainly that information would suffice. Also, the challenge with the net worth test is certainly it's very easy to verify assets, a little more challenging to verify liabilities. So if you are going to use that test, certainly a consumer report should be obtained so you can make sure that while someone might have sufficient assets to cover the $1 million, to the extent of which any liability should be debited from against those assets, you might want to pull a credit report. Again, to the extent of which someone is interested in using the annual income test to satisfy the test of being an accredited investor, you can use certainly some of the IRS forms that have been provided, to the extent of which someone's got a W-2 pay stub, a 1099 if they're an independent contractor that shows sufficient income to reflect the fact that they meet the $200,000 or $300,000 with a spouse, a Schedule K-1, or copies of their 1040 they filed for the 2 most recent years. That certainly would suffice. The challenge with that is, to the extent of which you can verify someone's income for the last 2 years, you also need to get information about the current year. So you need a representation from such person that they have a reasonable expectation of reaching that income level during the current year to satisfy the test of an accredited investor. So there is, the challenge of the Jobs Act, it is freeing in the sense that it allows you to really be free in your marketing and your ability to advertise. The challenge is it just requires additional compliance from potential investors, and therein lies the trade-off. The SEC is also basically, and I think this is the best solution of all, is that they've allowed, and it has to be someone with license. They want to have someone who's going to give a representation and warranty that someone is an accredited investor. They want to have someone with a license. So it's basically, they noted 4 buckets in their particular release. It's a registered broker-dealer, an SEC registered investment advisor, so state registered advisors unfortunately would not work. An exempt reporting advisor would not work. It has to be someone who's registered with the SEC as an investment advisor, a licensed attorney, or a certified public accountant. So there's got to be some license at risk. Any one of those four parties can basically provide a letter to the hedge fund manager and indicate that a particular investor is an accredited investor. So please keep that in mind, that to the extent in which you are going to use the Jobs Act on a 506C, that you have the ability to use a licensed third party who's obviously comfortable with the investor and that someone who can provide that rep and warranty. And I think the letter is the best solution of all, that folks who want to do that. And again, what that letter basically needs to say is that, to the extent in which someone is using the net worth test or the annual income test, that letter just needs to provide that they satisfy the definition of an accredited investor. And certainly something that I've used in the past, and every client I've had that have used the Jobs Act has used a letter because it's the easiest way to satisfy the verification test. And again, just to be clear, so 506B, no need to sign a subscription agreement would suffice. So that certainly works as part of for a 506B offering. One of the other changes that was made as part of the release in July of 2013 was a Form D, and just to explain exactly what a Form D was, some changes proposed to Form D, which I'll give you a little bit of background about Form D. So we mentioned before that the SEC allows, pursuant to Reg D, they allowed a private placement to occur under the 33 Act, which is that first triangle I did in the first slide, that an investor issues cash it provides cash to a fund. The fund issues securities in exchange for that. So that's done pursuant to Reg D under the 33 Act. And as we mentioned, the Jobs Act changed Reg D. So as part of that offering, or the offering of interest or the sale of interest at a hedge fund, the SEC has required the fund itself to actually file a Form D on the federal side. There are state compliance requirements as well, too, under the blue sky laws with Form D, but just in general, we're talking about the SEC and federal requirements for Form D. So Form D has to be filed within 15 days of the sale of a security. So if a fund launches on November 1st, 2014, within 15 days, a Form D has to be filed with the SEC. So now Form D, as part of that release that was passed in July of 2013, was now revised to include sections for both 506B and 506C. So to the extent in which someone is relying upon 506B, they can continue to do so. If they decide they want to rely upon 506C, they check that box as well. It was interesting. I read a few months ago a hedge fund publication indicated that they had done a story on a number of large institutional funds that had checked 506C as their exemption. You know, there's all this buzz that was indicated that these big funds were now taking advantage of the Jobs Act. When they were contacted, they realized that their legal counsel or someone in-house had actually made the wrong filing. So certainly be careful when you're filing your Form D. Please make sure that you check the right box depending on what you're relying upon, because it could have a significant effect on your compliance and your ability to, certainly if you check the 506C box, it's very difficult to rely back on 506B. So a couple things on that. So if you check Form D, you can't, unfortunately, check both boxes. Once you make a general solicitation, once you get involved in general advertising, unfortunately, you can't unscramble the egg. You can't ever go back to 506B. So once you've made the decision to rely upon 506C in the Jobs Act, you can't ever go back. So as soon as you make that first, that first general solicitation and general advertising of your fund, perhaps with a newspaper ad or putting your fund documents on the internet or sending out a mass blast email to a number of people about your fund, you have to now rely on 506C. And unfortunately, you cannot ever go back to 506B. Okay, so proposed rules. And so we've talked about, everything I just talked about is real, it's live, it's happening, it's out there. There's people taking advantage of the Jobs Act. Everybody's is on the same page with respect to what the rules that are currently passed. Well, the challenge is, and I think this is one of the holdups for why some hedge fund managers have not taken advantage of the Jobs Act, is the SEC in July of 2013 also came out with a number of proposed rules that there's been no movement on. So they're basically in this sort of purgatory of not clear whether they're going to pass, not clear whether they're actually going to fail. So certain managers have basically not taken advantage of the Jobs Act because they're not sure what their actual compliance is. So there's a number of proposed rules that are out there. And I'm going to walk through these proposed rules. These haven't passed. They were part of the July 13 release. They're out there. They could potentially pass. So certainly issues that certainly folks should be aware of to the extent in which they ever do want to check the box for 506C and use the Jobs Act. So as mentioned, July 13, more proposed rules came out that were passed, that were proposed but have not yet passed. Causes some certain managers who are concerned about additional compliance, some hesitation whether they should use the Jobs Act because they're concerned about these additional compliance they'll have to deal with. Really unclear whether they will be implemented, and to the extent in which they are implemented, whether what timetable they will be implemented on. So a few things about where the proposed rules are. So first, to the extent in which you want to engage in a 506C offering and engage in a public offering and engage in general solicitation, you would be required to file the Form D 15 calendar days in advance before the fund engage in that general solicitation. So now the current rule says you can file your Form D within 15 days of the offering. So, for example, a fund that launches November 1st, 2014, under 506, under current law and under 506C currently, that Form D would be required to be filed within 15 days after. So it would be something you file it November 16th, 2014. So the proposed rule says if you want to do 506C, you actually have to file that 15 days in advance. So 15 days prior to November 1st, 2015, you'd actually have your Form D filed if you were going to take advantage of the Jobs Act. So the challenge there is just doing a pre-filing per se. That's not the current rule. It's proposed. 506B and C both are 15 days after currently, but this would make it 15 days before, would actually move up the timetable for 506C by 30 days. So another proposed rule that's out there is that to the extent in which you stop engaging in 506C, you have to file a closing Form D within 30 days of the offering. So right now, if you shut down your fund, there's no need to do any subsequent filing of Form D. You just basically kind of shut down your entity with the Delaware Secretary of State or the particular regulator where you set up your fund, and you move on, and there's no Form D filing required. Under the proposed rule, within 30 days, you shut your fund down on October 31st, 2014. Within 30 days of that date, you'd actually have to do an ending file under 506C. Certainly would not be required under current law under 506C or 506B. And I think the third point is something that is most challenging for emerging managers who are considering using the Jobs Act, and this is basically submitting on a temporary basis written general solicitation materials used in 506 offerings. This is a proposed rule again. So, however, if you do go to the SEC website now, there is the ability for, it's called voluntary submission of 506C materials. So certainly, even under current law now, the SEC has allowed you to voluntarily submit, if you're taking advantage of the Jobs Act, if you wanted to submit your advertising materials to them, you certainly could do so. I think that's a terrible idea. I'm a big believer of everyone being in compliance, but I'm not really sure why anybody would voluntarily submit a submission that's not required. So I think this is the biggest sticking point for folks who are concerned about the Jobs Act. It's currently proposed rules, but they're just concerned about additional oversight and review of their documents before their ability to engage in a 506C offering. So that's one sticking point. Not clear whether it's going to pass. Another proposed rule that's out there is that to the extent in which a fund did not file a Form D, or one of the affiliates or predecessors of the fund did not comply within the last 5 years with filing a Form D, you couldn't offer your interest for a year. So they're proposing a 5-year look back to the extent in which that fund or an affiliate, the general partner or investment manager or the predecessor fund did not file a Form D at any time in the last 5 years. They're basically saying that you are not allowed to raise any additional capital for another year. Again, proposed rule hasn't occurred yet. Generally it doesn't seem to be a problem for those private funds that are in compliance with Reg D and have made a Form D filing, but those folks who have not certainly would have some issues under that proposed rule. Another proposed amendment under the Jobs Act that passed in July, or that was proposed in July of 2013, basically requires private funds to include additional information and basically some legend as part of the offering material. So certainly what would be required there is that your private placement memorandum would have to include certain language that investors who were subscribing to such offering would need to see. Well, how that exact language would look and the proposed disclaimers is unclear, but that is one proposed rule out there. And then there's basically this last rule, an amendment to Rule 156 that would basically extend anti-fraud guidance to the sales literature of private funds. Another proposed rule, they didn't give a lot of color on that in the initial release of the proposed rules that came out, but certainly something that's out there as well. Other compliance issues. And so I'd say that a few of the sticking issues that have been out there with why aren't more fund managers taking advantage of the Jobs Act. So first we talked about these proposed rules we just talked about. They're out there. They're a cloud out there. I think clarity is always, I always say it's ambiguity is tough for potential folks who are interested in being law-abiding citizens because they're just not clear what the rules are. So those proposed rules are a cloud out there that have impacted some managers' ability and willingness to use the Jobs Act. Another cloud actually that was out there but now has disappeared was this rule that the CFTC and the NFA recently made some amendments to earlier in September, and I'll walk you through that. So just to give you a little bit of background, so commodity pool operators, and so a hedge fund manager is also, it's subject to, we mentioned that first slide, we talked about those 4 Securities Act that are involved with for compliance. So in addition to the Securities Act is also CFTC, which is sort of like the governing body, and then there's also the self-regulatory organization called the National Futures Association, the NFA. They regulate futures, swaps, and other instruments in addition to the SEC. So they kind of work side by side with the SEC. The SEC regulates, in general, it's a lot more complicated than the state in general. They regulate securities. The CFTC regulates futures and options on futures swaps and other commodity interests. So that's their sort of regulatory body. So there are a number of hedge fund managers that are either registered as a commodity pool operator, which means that they operate a commodity pool or hedge fund, or they're registered as a commodity trading advisor, meaning they have separately managed accounts that trade futures, swaps, or other instruments governed by the CFTC or the NFA. So, but there are a number of hedge fund managers that are not registered as a commodity pool operator, or they comply with one of the exemptions under the NFA and the CFTC provided to hedge fund managers to allow them to enter into a de minimis amount of futures and swaps transactions. So one of those exemptions that's currently out there is called 413A3. It allows you to, and I won't bore you with the boring details with the exact test, but it's a two-pronged test that a hedge fund manager can rely upon so they can avoid being subject to the NFA and CFTC rules and regulations and being subject to audit by the National Futures Association. So the challenge was under 413A3, one of the requirements of 413A3 basically said that you can't, in order to rely on 413A3 and not become a commodity pool operator, you can't engage in public marketing. No general solicitation can use. So the challenge lied that folks who wanted to trade a de minimis amount of futures and swaps were interested in relying on that exemption. Basically, to the extent to which they ever wanted to use a Jobs Act, they were prevented from doing so because the laws of the CFTC and the NFA conflicted with the SEC. So I was very hopeful for a year that these regulatory bodies would get their to work together and somehow come up with a solution that would allow hedge fund managers who have a de minimis amount of futures and swap interests to actually use the Jobs Act. And what's happened in September 9th of 2014, a month and a half ago, the CFTC has basically given an exemption for folks who are using 413A3 and say that to the extent in which you want to use the Jobs Act, as long as you're sort of in compliance with the other principal parts of that rule, you can engage in a general solicitation and general marketing and still be in compliance with 413A3. Regulation 4.7, that's really for registered commodity pool operators, those folks that actually are not relying on exemption. They're actually registered under as commodity pool operators under Section 4.7. One of the requirements of 4.7 says that's for folks, as I mentioned, who are registered as commodity pool operators. It provides additional relief from some of the onerous requirements for commodity pool operators that they have to deal with under the CFTC and NFA rules and regulations. So one of the requirements of 4.7b says that if you want to avoid some of the burdensome requirements of compliance as a commodity pool operator, you only can offer your interest to qualified eligible persons. The challenge with that approach was if you want to use the Jobs Act and you put your fund docs on the internet, obviously you're offering your interest in your fund to more than qualified eligible persons, so you would violate Regulation 4.7b. So basically, in a nutshell, on September 9th, 2014, the CFTC and NFA basically said that those folks who want to use who rely on 4.7b or Regulation 413A3 can use the Jobs Act as long as they're in compliance with all the other restrictions that are involved in the compliance requirements under 413A3 and Regulation 4.7. You can use the Jobs Act and you won't blow your exemption there. And that's what it is in a nutshell. It's allowed managers who want to not register as a commodity pool operator to have the ability to use the Jobs Act, engage in general solicitation and offering, and not be subject to these burdensome rules. One of the points that release provided was, and I think I might have missed a slide here. I just want to make sure. Nope, I think we're okay there. One of the things I want to make sure that this, if you are 413A3 exempt, or if you're relying on 4.7b and you're a registered commodity pool operator, this exemption is not self-executing. You actually have to file a notice with the Division of the Swap Dealer and Intermediary Oversight of the CFTC. It's not something that allows you to immediately you actually have to file for it. You basically have to provide basic identified information on the entities claiming exemptive relief, and basically you have to indicate that you're relying on 506C, and then indicate which particular rule do you want. It would not be both, because someone who's relying on 413A3 would not be relying on 4.7. So you have to indicate whether you're looking for relief from Regulation 4.7b or for 413A3. So before I get into cost-benefit analysis for emerging managers, we actually have a question from Colin, and I'm going to read the question just so everybody is clear exactly. I actually have another question as well, but we'll start with Colin. The question is, are there any restrictions on what constitutes general solicitation, certain types of digital marketing? It's a great question. So basically, it's if anything, here's, I guess the way to explain or answer that question is that anything that's not in compliance with 506B is a 506C offering, and let me explain that a little bit more. So, in order to, under the current or the pre-Jobs Act rules, you basically needed to, in order to engage in an effective private placement, you had to have, do a couple things. You could not use general solicitation, so that sort of goes away. The other thing is you actually have to have a pre-existing relationship with a particular investor, and you have to make sure that pre-existing substantive relationship with that investor before you make the offering to that particular investor. So, in terms of what restrictions constitute general solicitation, basically it's if you can use anything. If you want to use digital marketing, if you wanted to have a blip at the Super Bowl, if you wanted to, whatever you want to do, if you want to put bumper stickers on cars, you want to take television advertisements, it's anything. It's anything that's generally broadcast, it's not done on private placement, that is now all allowed. There's no restrictions on anything that aren't allowed, of course, in compliance with other applicable law. I mean, certainly if you're, breaking into someone's home and putting up banners in their home about your new hedge fund, certainly that might work under the Jobs Act, but you might be violating a local town ordinance per se. Another question. Also, are there consequences if your solicitation actually targeted non-accredited investors? Just to be clear on that point, so 506, remember now, so I just want to be sure that everyone understands the rules. So 506B, non-Jobs Act says all of your investors, or you can take up to 35 non-accredited investors, okay? That's accepted into your fund. That's 506B. 506C says you can certainly market to everybody. You can put an ad on the Super Bowl, and you can put an ad on a blimp and about your fund. You can put T-shirts, however you want to market in a general solicitation. The key is it's two things: is all of your investors who subscribe to your fund have to be accredited. So it's not you can offer to anybody, but the ones who actually subscribe have to be accredited. And the second test is you have to make sure that you verify that they're accredited. That's the two tests. So certainly the question is. Also, are there consequences if your solicitation accidentally targeted non-accredited investors? No consequences whatsoever, because that's the point of the Jobs Act, is certainly putting, your blimp, unfortunately, just can't make sure that it's seen by non-accredited investors. Anybody can see it, so no issues there at all. That was from Matt. Let's see, another question. For the proposed new rule, the SEC is considering writing a Form D closing amendment. Would it only be applicable upon the complete shuttering of a firm, or would the proposed rule be allowed a 506B fund to close the door in a general solicitation, so to speak, and then convert therefrom into a 506B offering? So just to be clear on that, the closing amendment is really just not so much you can't. The closing amendment is basically when the fund is shutting the door. Certainly, once you've done the 506C. Once you've kind of hit the switch and filed a Form D that reflects the fact you're now doing you're engaging in a general solicitation under 506B, you can't ever convert back. So unfortunately, to the extent in which you ever want to convert back to a 506B offering, that would not be allowed. Once the cat's out of the horse is out of the barn, you can't ever go back. So the only way to do that would be to set up a new fund. So that closing amendment, while it is a proposed rule, it basically is when the fund is actually shutting down, and it would not really apply when a fund just is looking to sort of convert back to a privately offered fund that's not relying on the Jobs Act. So those are the questions for now. Folks who have additional questions, feel free to chime in. We're happy to address those. So last part here, so the cost-benefit analysis for emerging managers. And this is just my general thoughts on some of the advantages and disadvantages of where we stand now under the Jobs Act. So I think, the upside of the Jobs Act, and really what's attractive about it, is your ability to really not be tripped by compliance rules. I think one of the challenges I see as a compliance attorney and a hedge fund lawyer who sets up a number of funds for folks is that there are different degrees of aggressiveness among all different funds. I constantly hear from clients, well, this particular competitor of mine has this on their hedge fund. They market their hedge fund on a particular site, and why can't I do that? And, this person's doing this, and why can't I do that? And what is a pre-existing relationship? What's a pre-existing substantive relationship? What are all these? Explain this all to me. Explain me how all this works, because I don't get it. This person did this, and I don't understand these rules. They're all so gray. So I think one of the nice parts about 506C says, look, the rules are pretty clear. Do whatever you feel like. That's basically the general rule. There's no more, it's advertised to whoever you want. As I said, if you wanted to take out a Super Bowl ad, you can certainly do that. There's no more, so I think your calls to your attorney trying to make sure you're staying in compliance with 506B will certainly become far less frequent, because you can just basically engage in whatever you want. So that's one nice upside of 506C. The other nice upside is, I think there's, unlike other industries that have folks on Madison Avenue at their disposal to help them with marketing and whatnot, I think the challenge for hedge fund managers who are, in the asset management business, unfortunately, is about raising assets. So, I always counsel folks, keep your expenses low, because your assets and revenue is uncertain. Your revenue is based on your assets. So if you don't know what your assets are going to be or your performance, so keep your expenses low. The challenge is, for folks who have gone out and had a tough time raising capital, they're at this turning point of, I really enjoy, working for myself, managing my fund, but I don't have sufficient assets to support myself. If I don't gain enough assets, I'm going to unfortunately have to either, find another job or shut down my fund and work for somebody else, which is challenging once you've kind of gone out on your own. So I think what the Jobs Act has allowed, it's allowed, industries, marketing and other professionals to become involved in the equation. So certainly if you want to get involved with PR firms, you want to engage in, discussions with people who might give you some better presence on the web, you certainly can have a more fulsome website in terms of, your ability to market your fund and put your fund documents on the internet. You don't have to have them behind a cloud anymore. I think that's obviously an advantage, and certainly allows folks to, instead of sending out burdensome packages of fund documents, you can basically say, hey, look, here's my site. Here are my documents. If you're interested in investing, please just send us a subscription agreement. That certainly works. I think that's, one thing I see is from emerging managers, it's just distribution. That's their biggest challenge, is that they don't have sufficient distribution. The Jobs Act solves that issue for them. I think that's a great advantage. I think the challenge, so disadvantage of the Jobs Act is I think, and this is where I would encourage the SEC to provide clarity, really think that the only thing worse than a bad law is just not knowing what the rules are. So I think at this point, because of those proposed rules that we discussed earlier in this webinar, a lot of emerging managers don't know what the boundaries are. They're not clear exactly what's allowed and not allowed. So a number have just not been, they've been reluctant to actually go forward with the Jobs Act because they really don't understand what the rules are on that side. And I think that's one of the disadvantages of Rule 506C, is it's just not clear what the rules are. And I think I would hope that, the SEC would certainly make that a priority to get, their act together and really go out and try to make it clear what the rules are. And I think, the other disadvantage of Rule 506C is that it requires a little bit more from investors. I think the challenge is in this particular environment, very tough time to raise capital. Folks are really reluctant to ask for any additional information from investors that they need. This ability to verify that an investor is an accredited investor certainly provides more burdensome compliance with someone. I do think the best solution here is to allow a third-party advisor with a license who can provide a letter to the hedge fund managers, so that will satisfy their verification requirement. Everybody's happy. The licensed CPA or licensed attorney who has information about the client, there's no additional information that needs to be exchanged hands. Certainly just a letter needs to be signed, and that's the easiest way to deal with it. So I think for folks who are interested in taking advantage of the Jobs Act, certainly that particular letter that you could send to a licensed third party certainly works. Best practices for emerging hedge fund managers who decide to use 506C. I think a couple thoughts on that. So one of the things that I mentioned in that first slide was everybody on the phone who manages a hedge fund has one of four statuses on the hedge fund manager side. Certainly there's SEC registered advisors, there's state registered advisors, there's exempt reporting advisors, and there's also someone who's just not, it doesn't fall into any of those three buckets. The thing I would counsel those who are considering using the Jobs Act is make sure that you are adopt policies and procedures exactly how you are going to use the Jobs Act if you are registered with a particular regulator. If you're registered with the CFTC and a member of the NFA, if you're registered with the SEC as an investment advisor, registered with a particular state, you should make sure that's part of your policies and procedures. You come up with Jobs Act procedures so you make sure this is how we verify that particular investors are investors. We make sure that we check 506C as part of our Form D filing, and to the extent in which any of those proposed rules come into play, they have the ability to add those particular requirements into the compliance manual if the hedge fund manager is a registered entity. Other best practices, I think, is really, and this is where I think, when I launched my company 5 years ago, someone said to me, well, how do you market? And I think, what works, and I always say, everything and nothing. I think the thing with marketing is you just have to try different means, and I think the key is just trying different methods. So I think the Jobs Act actually provided a huge opportunity for folks who want to be creative. To the extent in which you want to get a list of accredited investors and send out keychains with or some trinket with the name of your fund with that. Certainly it's opened up the box of creativity. I think one of the challenges of managers in the past has been you can't really be that creative. Everything's on a private placement basis. You can't really use Madison Avenue, your own personal marketing skills to really market a particular offering. Now you can do that. Now you can, if you wanted to have T-shirts print up, you wanted to be engaging in things that operating companies, that are using, Kickstarter or doing other creative things in terms of YouTube videos or trying to get something viral. You could do an ice bucket challenge that try to get something viral about your fund. It really opens up the creativeness, and I really, as someone who is an entrepreneur and who's how to market my own company, I find that to be pretty liberating and kind of exciting that folks can do that. So I'd say thinking outside the box is definitely a best practice. Using I think everyone on the phone is probably excellent at evaluating companies, but using your marketing side of the brain and using other resources to engage in marketing, I think could be helpful as well. Third parties who may be helpful in helping managers who want to pursue 506C. I think a couple points on that is first, if this is something you are considering, really make sure that you're, one of those 4 folks of investors is willing to work with you, whether it's a licensed attorney, licensed CPA, a SEC registered advisor, or a registered broker-dealer. I think, for folks of that, you want to make sure that they, particular investors who, when you use the Jobs Act, that you've got relationships at those particular, with those relationships with those service providers who are licensed who can do that. Certainly, you're not going to be aware of exactly who a particular investor relies upon, but I think that's the key part of this, because having an investor provide information to a manager that they aren't familiar with in bank statements and W-2s really just sours the relationship, so you have to make sure that I think the third party is absolutely key. So those third parties who can verify on behalf of the manager an investor's accreditation status, I think is critical. And just I think the nice part about the Jobs Act is there's a lot of emerging businesses that are developing as a result of the Jobs Act, folks that are just seeing an opportunity here, whether it's third-party accreditation services or to folks who are now going to help you market, or folks who see opportunity here to help funds convert from a 506B offering to a 506C offering. Those are firms out there that are pursuing opportunities to allow managers who are looking for different avenues to capital, who want to currently engaging in 506B, who want to see, hey, look, I don't really want to pay my attorney additional money to help me convert from a 506B to a 506C offering. How do I do that? And I've seen services that are coming out that are going to allow those to convert from a 506B to a 506C. So certainly those services I think can add a lot of value. Final thoughts on the Jobs Act and Rule 506C, I think, is, first and foremost, I really, really encourage folks to consider it. It's a way to allow you a better access to capital. It'll allow you to, as I mentioned, the asset management business is about gaining assets. And if those who have tried traditional means, who are engaging in 506B offerings, not taking advantage of the Jobs Act, certainly you've been out there. If you've tried placement agents, if you've tried first loss programs, if you tried fund-to-funds, if you tried all different methods, seeders, all different ways to gain capital, certainly the Jobs Act is now an additional avenue that it gives you a whole new arsenal of tools to take advantage of raising money. And it's uncharted waters. I think we're at a point in time now that we're kind of at an inflection point, and I see now that, especially since the CFTC and the NFA have moved on their compliance requirements for under a 413A3, you're now allowing managers to really engage in this without being subject to additional compliance. So this is, I see that, in a couple of years, this is going to be a lot more commonplace. You'll be watching, the Pats against the Broncos and the AFC title game, and you'll see an ad on TV, for a hedge fund manager. I think right now that's not really happening. So there's an opportunity here that I think in a couple of years, I see that this is kind of blue ocean. There aren't a lot of folks who are doing this, and I see it's a huge opportunity for folks. So one last question here. So before, and if other folks have questions, I'm happy to address them now to help. Let's see here. Is it possible to, the question is it possible to set up a feeder fund under 506C and have that fund roll into an existing 506B fund? So just so people understand, you're now having a, I just want to make sure I understand the questions in terms of, there's two different ways to think about that. So a master feeder structure, if you have an offshore feeder and an offshore fund, or a Delaware fund and a BVI fund that falls into a master fund. I'm not sure if let me just see if there's more information about this question I can give you here. Let's see. Here's a particular question. This is, I think, is it possible to set up a feeder fund under 506A and have that fund roll in an existing 506B fund? I would say the answer to that question is no, and I'm assuming that it's still part of the same complex per se, in the sense of it's not a fund-to-fund. So certainly a 506C fund that was offering its interest to investors under the Jobs Act could invest into a, say it was a fund-to-fund that wanted to engage in 506C, could certainly invest into a 506B fund that was not affiliated with them. It's not really clear under the current rules, but my sense is if it's an affiliated fund, they really wouldn't allow that. But that's something the SEC hasn't commented on, and it's actually a good question. But unfortunately, my general sense is that if it was an unaffiliated fund, that 506C fund could invest into an existing 506B fund, but not if it was part of the same master feeder structure. Another question.
Hey, Doug.
Yeah.
I have a question I get asked by a lot of my managers. It's a very simple question, but there appears to be a lot of confusion around it. As far as the state filing, the registrations, when do you file the state registration? Is that at the point where you're taking an investor from that particular state, or is that something that you do when you engage after your Form D filing?
Good question from Willie. So the question asked was just related to, everything we talked about is dealing with, federal laws per se. Nothing in the discussion so far has dealt with state laws. So what Willie's asking about is state law compliance, and how does the Jobs Act affect state law compliance? Great question. So the short answer is the Jobs Act has not in any way, it's a federal law, has not affected blue sky or state. When I refer to blue sky laws, I refer to state securities laws. Every state in the United States has particular state securities laws you have to comply with. And one of the requirements is typically, it's all done on a state-by-state basis. Generally, the requirements match the Form D requirement. It has to be done within 15 days. Sometimes there's a Form U2 that's filed, and there's typically a filing fee, and there's, it depends on where the check needs to be sent, and the filing needs to be sent, and who it needs to be made out to. So it's all state-by-state, on a state-by-state basis. But the Jobs Act has had no effect on that. So to the extent in which you're engaging in a 506B or a 506C offering, there's no change in your compliance on the state level. It's just been changed on the federal side. But unfortunately, there's a hodgepodge of rules out there that are, it's basically every state, and it's only not where you're offered, it's really where the interest is sold. So if you sold an interest in the, U.S. Virgin Islands, you'd have to deal with U.S. Virgin Islands state blue sky laws. If you made a sale to an investor in Maryland, you'd have to deal with Maryland blue sky laws. And unfortunately, it's all done on a state-by-state basis, and the laws constantly change. So that's one challenge for managers, is that they still have to deal with these. But that's something that both 506B and 506C funds both have to deal with. Let's see. I think we have some more questions here. So we manage a BVI-based unregistered professional hedge fund. We have to date not solicit any U.S.-based investors and have no U.S.-based investors active within the fund. We would like to begin soliciting U.S.-based investors. Will we be required to comply with 506B and file out Form D, or are we exempt based on our jurisdiction? Great question. So the question basically is you don't have to engage in 506C. If you're offering interest in the United States, you have to either do a 506B or a 506C offering, so you don't need to use the Jobs Act. If the jurisdiction is offshore, if the interest is offered in the United States, so typically non-U.S. funds are offered to tax-exempt investors in the United States. That's typically what I see. And if those are offered in the United States, same analysis that applies to funds based in the United States. You have to either rely on 506C or 506B. There's no exemption based on the jurisdiction. Let's see. Please talk a little bit more about how pre-existing substantive relationship is defined and how it enforced. How do emerging managers work with 506B to maximize the investing universe? Great question. So this is where I feel tons of questions from folks is, basically what the rule says under 506B says that before you offer an interest or a security to an investor, you have to have a pre-existing substantive relationship with that particular investor. So tons of questions about what actually that is. And my general sense is if it's unclear of whether you do have a pre-existing substantive relationship, which is a facts and circumstances test, I really suggest before you make an offering, you actually create that relationship. So, let me give you an example. If someone introduces you to a potential investor and is someone you haven't really met before and you meet with them all over the phone, you really want to make sure that if anyone ever challenged whether you had an pre-existing substantive relationship with, you create that relationship before you actually solicit them and offer your fund documents to them for potential investment. So, in essence, it's the type of thing and you want to document that. So if
Oh dear, it looks like Doug has dropped off today's event, or at least the audio portion. I'm going to give Doug a chance to come back in. So what I'd like to do at this point is to run a poll. Now, notice what I'm going to do is put a polling panel on the screen, and I would appreciate your feedback for our management team. Notice I've just opened it up, and there are 3 short questions there. If you would simply make your selection, and then notice there's a submit button in the lower right-hand corner. That will allow me to compile the results. By the way, there is an input field in question number 2. That makes a great spot for you to add any comments or suggestions that on other topics you might like to hear about these webinars. Your input is important in bringing these types of events to you, so I would appreciate the feedback there. You have about 10 seconds left, so please finish up and make sure that you do remember to click that submit button so we can compile those results. And hopefully we'll get Doug to redial in and finish up with any of your questions. Thanks, everyone, for your patience here. Well, thanks, everyone. The poll did end, and hold on, and we'll get back to you momentarily.
I apologize. I've dialed in again. Hopefully folks can hear me. Maybe it was someone who was not a Denver or New England Patriots fan decided to pull the plug on me, so I apologize if I have offended anyone.
Well, it's good to have you back, Doug. Thanks for dialing back in.
You're welcome. Yeah, I don't know how much you missed there. Can folks now hear me, or it sounds like I could hear Cynthia. I think she can hear me. So
yeah, we can hear you, so you're back in.
Terrific.
And if you simply scroll back up in the chat panel, I think there were a few extra questions
there. Okay, perfect. I'm happy to address. Let's see what other folks I have today. Let's see. Going to chat here. Let's see what folks have. let's see. Okay, so this is, I guess, the crowdfunding provisions. I think I addressed that, but I'll address it again. I think I was only talking to myself, so sometimes I do that. I do talk to myself, but apparently my audio was not working. Aren't there crowdfunding provisions of the Jobs Act, and could these provisions be used for the purpose of raising a fund, particularly a closed-end fund? So, great question. I think so. As I mentioned at the onset, the Jobs Act involves all sorts of different sections. When I think about crowdfunding, I think about it's the ability to not only offer securities, but it also, to the extent to which folks want to have people, for example, if you want to have a microwave popcorn popper product that you wanted to offer people the ability on Kickstarter, that type of thing, the Jobs Act allows that. So certainly the Jobs Act has all different sections as part of its, it's part of its act. We've focused today strictly on the accredited investor piece of the Jobs Act. There is also a non-accredited investor piece. So certainly there are all different various provisions under the Jobs Act you can use, but the one we've talked about is those that applies to private fund managers. So, but there are other provisions that apply to more to operating companies and other folks, if you will. Let's see. I think that might be it. I don't see any more questions at all. But first and foremost, I really would like to thank Cynthia and Willie Katz and Interactive Brokers. I have numerous clients in common with Interactive Brokers. I'm a huge fan of their organization, and I highly recommend everyone on the phone to reach out to your Interactive Brokers rep and engage in dialogue. And certainly, very much appreciate the time. I know it's almost 10 of 6 on the East Coast, and certainly if folks are interested further, discussing the Jobs Act, here's my contact information. Happy to discuss, and really appreciate your time, and thanks so much, Cynthia and Willie, and I really enjoyed your time as well, everyone on the phone.
Doug, thank you very much. We appreciate all your efforts, and we'll look forward to talking to you soon. Thanks, everybody.
And everyone, remember to watch for a link in your email. It will be coming shortly. If you want to come back and review any of the concepts that Doug went through today, we'll be sending you a direct link to today's recorded playback. Thanks, everyone, and thank you, Doug. What a terrific presentation.
You're welcome, Cynthia. Have a great day. Thank you.
Okay, and to all who have participated this evening, I want to thank you for your time. We do appreciate the time you've spent with us. Have a great day or a great evening, everyone, and please remember to trade smart. By the way, you can exit using the X in the upper right-hand corner of the screen. Thanks all. Have a good one.